2018 484, State of Arkansas versus Ryan Wade Hammocks.
And I think we have at least a temporary resolution on Mr. Hammocks. If I could announce that to the court.
Yes, you may.
Your Honor, Mr. Hammocks' bond by agreement with the state is being reduced to $5,000. He has been in our jail since November 2 of last year. He is going to immediately enroll upon his release in Wilbur D. Mills. He is to complete Wilbur D. Mills.
Now Quapaw.
That's correct.
Yes.
Yeah.
I did not know that.
Okay,
He will
just-
live in the interim between the time he gets out of jail and he can get accepted into Quapaw at 512 Power Street in Mountain Home. But the stipulations that we worked out with the state, Your Honor, are that upon his release, as soon as he enters Quapaw, if he would leave that program at any point, he would immediately return to jail. And the matter would be continued on my motion, obviously pursuant to the court's approval.
Well, at this point, the case is set for trial during the week of June 24th.
Then let's just leave it as is for right now, Judge.
And what I'm going to do is set it down for a reappearance in this court on May 30th, or if we're going to extend the date out for the trial and everybody's in agreement on it, and he's in full compliance with the conditions of his bond, that is that he be at the Quapaw Center at that point, and it needs to be for a longer period of time, then we don't actually have to have him appear on May 30th, but I want to set date for him to appear back so we check on the status of his case and just not let it sit out there. Mr. Hammocks, do you understand that the bond in your case is being reduced to $5,000 cash surety, and a condition of that bond is that you enter into the treatment program at Quapaw House in Searcy, Arkansas?
I do understand.
All right, and so you'll be there until you complete the program, at which point you need to be in touch with your attorney and appear back here. We're setting you down for an appearance on May 30th to make sure we check on the status of your case, because your case is currently scheduled for trial during the week of June 24th. And that date at this point is not changing. If for any reason you leave Quapaw without completing their program, you need to one, contact your attorney that you're leaving, and two, you'll need to check back in at the jail, and we'll reassess where you stand.
May I speak for a moment, Your Honor?
Yes, sir.
It's my understanding also that there are more than one Quapaw centers. I wasn't aware that Wilbur D. Mills had become Quapaw. However, with that, in light of that, if it will speed the process for me to getting accepted, would it be okay with the courts to apply at every center?
Well,
not just one in Searcy?
there's only one that's inpatient.
Oh, okay. Okay, I see. I didn't know that. Thank you, Your Honor.
What the agency called Quapaw House has taken over treatment programs throughout this region. In this, they call it a catchment area, and they're responsible for treatment. But they only have one inpatient place, and at this time we're talking about the facility of Quapaw House in Searcy, Arkansas.
And Your Honor, the state wants it to be clear that's where we want it. It's the inpatient facility. I know that he has a relationship with another individual who's in another Quapaw facility, and we do not want them in the same location.
All right.
Okay.
So that, just so it's clear, that bond is conditioned upon you being in the Quapaw facility in Searcy, Arkansas. All right?
Sounds good.
All right. You may be excused at this time.
Thank you.
Two 2018-492, State of Arkansas versus James McDaniel.
Can I inquire of him, Your Honor?
You may.
Mr. McDaniel, how long have you been in jail?
129 days.
All right. Do you have a hold on you from anywhere else?
I believe Marion County.
Your Honor, his bond is at $25,000. The allegations that I'm looking at are a terroristic threatening, which is a Class D felony. Given the nature of the charge, if there is a restriction about no contact with the victim, which obviously that there would be, or the alleged victim, I would ask for a substantial reduction in his bond to give him an opportunity to bond out.
I believe there's a revocation hold out of Baxter County too.
The bond was set and approved by the officer, by the judge who reviewed the affidavit. I've reread the affidavit. I'd read it before. Reread the affidavit, and it appears to me that I would imagine the state is resisting any reduction. Is that correct?
We are, Your Honor, based upon this situation and his history, Your Honor.
I don't know in any way that, given the nature of the threats that are the basis of this terroristic threat, and having had no information provided to the court to counter that, court's going to leave the bond at $25,000. I will condition upon no contact with no direct contact with the personnel at any of the personnel at Legend Boats. So that'll be a condition on the bond.
Your Honor, before the court releases him, Mr. McDaniel needs to fill out an application.
I have one completed already.
Well, okay, on the revocation?
Yes.
Okay, because, Your Honor, we were unaware of that. That is on Judge Putman's docket.
But do we know the number on that?
Yes, Your Honor, that is 2014-85.
There is a petition to revoke suspended sentence. It was filed on November 16th of 2018. It's based on this new charge. This file reflects that he was given a court date of December 6th, but there's no record of, in the file at least, of any appearance on that court date at the time he was arrested. In case 2014-85, I'm going to order him to reappear in front of Judge Putman on March 28th. Mr. McDaniel, the court is not going to reduce your bond on the new charge. You're being held on a no bond hold on that revocation case, which is assigned to the docket of Judge Putman, and I'm ordering you to reappear in front of Judge Putman on March 28th. You may be excused at this time. 2019-55, State of Arkansas versus Aaron Tallis. We also have 18-287 and 17-460 with the same defendant.
Your Honor, in all of Mr. Tullis's cases, and this is a very recent development, the defense and state have now agreed that, again with obviously the court's approval, that Mr. Tallis would be released on an OR bond from our jail. His cases would be continued on defense motion, and he would be immediately picked up and sent to Care Center Ministries. He has been seen, and he's been accepted, and that is the agreement that we have with the state.
We have him on this case on a scheduling order that has him set for trial in August. Has he been arraigned on this?
I believe he has been, Judge.
Yes, he was. Okay. February 7th. The case was transferred to Division 4 on that date, and he was arraigned, entered a plea of not guilty. All right. After consultation with counsel about how to arrange things, in cases 2019-55, which is already set for trial the week of August 29th, and in cases 2018-287 and 2017-460 involving Mr. Tallis, which is currently set for trial next week. The defense is making a motion to continue the latter two cases. They'll be continued for the trial week of August 19th of 2019 as an excluded period, and the court is at this time. There's a reappearance date in these. I'm gonna move the reappearance date back to for all of these cases to July 15th. No, excuse me. No, that's no, to August 1st. So there'll be a new reappearance date on August 1st. That's just to check on the status of Mr. Tallis. Now, the court is going to authorize an OR release of Mr. Tallis from the jail. The arrangements, I think, are being made to pick him up for Care Center Ministries to pick him up. The conditions of his release are that he remain in Care Center Ministries under treatment, and that if he leaves there, other than well, if he leaves there for any reason, he needs to check himself back into the jail. It's just that simple. You're not going to be any place but in Care Center Ministries, sir, unless you make some arrangements through your attorney and they're approved by the court. So that'll be, you'll be in that program. We'll check on the status of things on August 1st, and you either try the matter, start trying your cases in August, the week of August 19th, or we may be willing to continue them out as long as you're continuing in treatment. So that's your status at this point. You understand, sir?
Yes, sir. Thank you.
All right. That'll be the order of the court. (2010-313) State of Arkansas versus Evan Webb. The most recent petition to revoke filed on Mr. Webb.
Yeah, no, he is ours, and I think he is here today because he failed to appear last week.
Now, I'm trying to go back and find when the original petition was. There was an affidavit filed in September and a petition in September of 2018 on non-payment of fines, and I don't find a more recent petition filed. He did appear before this court on on January 17th, and looking it up, because Judge Putman was the last judge on a sentencing order, I put him down to reappear in front of Judge Putman on January 24th, and I think that's... He was then ordered to reappear in front of Judge Putman on February 14th. On February 14th, he failed to appear, and a warrant was issued. And I think that's what brings us up to this point. He's got a failure to pay, failure to comply petition that was filed.
Yes, sir. I was unaware of all that. I assumed since I was allowed off of parole that I was more or less good to go. I've been off of parole a good 6 or 7 years now.
Have you been paying your financial obligations to the sheriff's office?
Well, I was when I was on parole, I was giving my parole officer a money order every month, assuming that was what I was supposed to do.
Coming off parole doesn't relieve you from meeting those financial obligations, and that's what's resulted in this latest petition.
I understand. I was unaware. I'm not a career criminal. I don't exactly know. I thought that since I was, taken off of parole that I was good until this warrant came up in last year in, I believe, November or.
Yes. Have you made application to the public defender's office?
I have one right here, but I should already be being represented by Sam. However, I've tried numerous times to call the public defender's office, and I can't get a call back or anyone other than the secretary.
Well, Mr. Pasting has been appointed to represent you in that. I'm informed. That's Sam Pasting. And so you need to call, make an appointment to see him, and then get in to see him. All right?
Well, is there a possibility that I can come this afternoon and resolve all of this?
Well, do we have any reason to believe Mr. Pasting would be here this afternoon?
Your Honor, he'll supposedly be here, but this is a Judge Putman case.
But, Mr. Webb, you were my original judge on the original charges that I went to prison for, that I'm being in contempt of, I believe. Right?
Well, it's confusing because you've had several times you've been back in front of the court, and I know Judge Putman signed the last sentencing order that was signed, but I'm going to direct that you be brought over, and let's see if we can't we can't get you with Mr. Pasting, and see if we can't resolve this matter.
Thank you, Your Honor.
All right.
Thank you.
You may be excused.
Do I need a new public defender form, or am I good?
Yes, he's already got Mr. Pasting.
Yes, he does.
All right. You're properly appointed to Mr. Pasting. So my hope is that Mr. Pasting will be here, and you can talk to him, and then we can see what can be worked out.
Thank you, Your Honor.
All right. You may be excused. James Faro, we have 19109.
Your Honor, I just did want to let you know up front that I just want to go ahead and read them all out if I can.
19109 is, of course, assigned to Judge Putman's docket. It's a first appearance. The charges on this are possession of a controlled substance, Class D felony, and possession of a firearm by a certain person, a separate Class D felony. Have you made any application to the public defender's office, or have you arranged for an attorney?
I had filled out an application, but I gave it back. I didn't sign it.
So you didn't sign the application?
Yeah, I was in a hurry to get it before he left the cell block.
Well, you need to, if you're gonna ask for the public defender's office, you need to sign the application. I mean, I can't appoint somebody unless you fill out that application and apply for it.
Okay, can I just go ahead and plead this all out on my own? I'd rather just plead it out and get it over with.
Your Honor, if I'm understanding this correctly, he is actually on Judge Putman's docket.
Yes.
And certainly if he wants to fill out an application and we're approved, then if Mr. Hastings would be representing him, I don't know what we can do today since he's on Judge Putman's docket.
Do we have an agreement on this old case, revocation case, 01-146?
Well, again, Judge, he's not applied, so no, we don't have an agreement.
The note here is what made me think maybe we already had an agreement. No.
It's a brand, he was just served on that, Your Honor.
Okay. Mrs. Scalfaro, the situation is, I made a practice not to accept guilty pleas on felony cases from people who have not even talked to an attorney.
Yes, sir.
And so I'm not going to take a plea from you today. Your case is assigned to Judge Putman. That's case 2019-109. The other case that you have listed on this docket is a case that predates even when I was a judge, became a judge. It goes back to the time when I was technically the prosecutor on that case.
Yes, sir.
Because it's a 2001 case. And so what I'm telling you is that I don't feel comfortable taking a plea on either of these cases. And so what I'm going to do is direct that you reappear in front of Judge Putman in a week on March 28th. I will enter a plea of not guilty for you on the case 2019-109. I recommend strongly that you fill out the application for the Public Defender's Office and sign it. I'm not going to take any pleas today, so you aren't losing anything. You can take that up with Judge Putman on that March 28th date.
Okay. Your Honor, may I ask you one more question, though?
Yes,
on that
sir.
matter of that $894, can I have that put back in my personal? See, they originally arrested me. They said I had 3 accounts of delivery, and they got it goofed up. It was from that old warrant from 202, but they took it $894. I was wondering if I could get it put back in my personal.
I don't know what you're talking about.
There was a matter of $894 they took from me that day. And when I got arrested home by Mountain Home PD, they thought that I was getting arrested for 3 accounts of delivery. And it wasn't. It was from that charge from 2002.
You know, that's not the case. He was arrested for possession of methamphetamine and possession of firearm by certain individuals and had cash in his possession at the time they arrested him, Your Honor.
And that was just simply confiscated?
Absolutely, Your Honor. And there's a civil forfeiture pending, Your Honor.
If you want that explained to you, that's why you need an attorney to understand that.
All right.
So what I'm telling you is make application to the Public Defender's Office, get an attorney appointed on your case, and discuss these matters with him. All right?
Okay, thank you.
All right,
Thank
you
you.
may be excused.